We the people now redeclare the Declaration of Independence, brought forth in Congress July 4th, 1776, and redeclared for and by we the people, November 25th, 2012. The unanimous Declaration of the 50 United States of America. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men and women are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men and women, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive to these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence, indeed, will dictate that governments long established should not be changed for light and transient causes, and accordingly all experience hath shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. Such has been the patient sufferance of the states, and such is now the necessity which constrains them to alter their former systems of government. The history of the present corporate United States, a fiction, unlawfully posing as the legitimate constitutional republic form of government guaranteed by the organic Constitution for the United States of America, is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. It has refused its assent to laws, the most wholesome and necessary for the public good. It has forbidden its governors to pass laws of immediate and pressing importance unless suspended in their operation till its assent should be obtained or its subjugation adhered to, and when so suspended, it has utterly neglected to attend to them. It has refused to pass other laws for the accommodation of large districts of people, unless those people would relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyrants only. It has called together legislative bodies and foreign usurpers at places unusual, uncomfortable, and distant from the depository of their public records for the sole purpose of fatiguing them into compliance with its measures. It has dissolved representative houses repeatedly for opposing with manly firmness its invasions on the rights of the people. It has refused for a long time, after such dissolutions, to cause others to be elected, whereby the legislative powers incapable of annihilation have returned to the people at large for their exercise, the state remaining in the meantime exposed to all the dangers of invasion from without and convulsions from within. It has endeavored to prevent the population of these states, for that purpose obstructing the laws for naturalization of foreigners, refusing to pass others to encourage their migrations hither legally, and raising the conditions of new appropriations of lands by theft and bribe to foreign entities, that which rightfully belongs to the people. It has obstructed the administration of justice by refusing its assent to laws for establishing judiciary powers in common law. It has made judges dependent on its will alone for the tenure of their offices and the amount and payment of their salaries. It has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. It has kept among us in times of peace standing armies without the consent of our legislatures. It has affected to render the military independent of and superior to the civil power. It has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving its assent to their acts of pretended legislation. For quartering large bodies of armed troops among us, for protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states and other nations, for assaulting our trade with all parts of the world, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury, for transporting us beyond seas to be tried for pretended offenses, for abolishing the free system of laws in neighboring provinces, establishing therein an arbitrary government, and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these states, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments, for suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases whatsoever. It has abdicated government here by declaring us out of its protection and waging war against us. It has plundered our seas, ravaged our coasts, burnt our towns, seized our homes and property, and destroyed the lives of our people. It is at this time transporting large armies of foreign mercenaries to complete the works of death, desolation, and tyranny already begun with circumstances of cruelty and perfidy scarcely paralleled in the most barbarous ages and totally unworthy the head of a civilized nation. It has constrained our fellow citizens taken captive on the high seas to bear arms against their country, to become the executioners of their friends and brethren, or to fall themselves by their hands. It has excited domestic insurrections among us, and has endeavored to bring on the inhabitants of our lands the merciless savages whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. Nor have we been wanting in attentions to our domestic and foreign brethren. We have warned them from time to time of attempts by their legislature to extend an unwarrantable jurisdiction over us. We have reminded them of the circumstances of our immigration and settlement here. We have appealed to their native justice and magnanimity, and we have conjured them by the ties of our common kindred to disavow these usurpations, which would inevitably interrupt our connections and correspondence. They, too, have been deaf to the voice of justice and of consanguinity. We must, therefore, acquiesce in the necessity which denounces our separation and hold them, as we hold the rest of mankind, enemies in war, in peace, friends. We, therefore, the people of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentionism, do in the name and by authority of the good people of these states solemnly publish and declare that these United States are, and of right ought to be, free and independent states, that they are absolved from all allegiance to the fictional corporate entities, the British Crown, and all other foreign fiction usurpers, and that all political connection between them and the United Nations or any other nation is and ought to be totally dissolved, and that as free and independent states they have full power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which independent states may of right do. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. In addendum to an amendment of the aforesaid, we the people further declare. A Declaration of American Sovereign Authority, the surrender of the separation of power doctrine. As was the desire of our founding fathers for independence in 1776, so it is the desire and the obligation of we the people in the year of our Lord 2012 to declare independence from the privileged class that has taken control of all three branches of government and rendered our republic an oligarchy in direct violation of the Declaration of Independence and the United States Constitution. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government. Government long established should not be changed for light and transient causes, and accordingly all experience hath shown that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpation, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. Americans have lost the protection of the Seventh Amendment. Common law. Lost is the faith and the trust in the United States government and the American people's desire to speak and act on a main cause. Attorneys and lawyers. Such has been the patient sufferance of the citizens of the United States, and such is now the necessity which constrains them to restore these United States to the form of government as established and mandated in the organic Constitution of the United States of America. The United States Constitution is the foundation of the law upon which our country is based, and the rock upon which an unequaled prosperity for our citizens has been achieved for over 200 years. To part from this successful formula could only be imagined by a self-serving individual or group of individuals who have no respect or concern for the sacrifice of our founding fathers, the sacrifice of our heroic veterans and their families, or for the love and patriotism of the vast majority of the citizens of the United States. Today, The rights, privileges, and freedoms guaranteed by the Constitution, the organic Constitution, have been prostituted, polluted, trampled upon, distorted, redefined, and corrupted in a giant law factory created by and for the benefit of the attorney-lawyer culture. We see the tragic results all around us. The myriad of economic problems, the loss of individual freedoms, and the deterioration of the American spirit over the last few decades are in direct relationship with the proliferation of an attorney-lawyer class occupying the majority of public offices and controlling all policy and lawmaking apparatuses of our government. In 1950, Washington, D.C. had 1,000 attorney lawyers. In 1975, it had 11,000. By the mid-1990s, the number of attorney lawyers had ballooned to approximately 65,000. By December 2009, the estimate had grown to 80,000, representing over 15% of the entire population of Washington, D.C. America now, with over 1.2 million, has over 70% of the attorneys and lawyers in the world, with law schools adding another 40,000 per year. America is polluted with one lawyer for every 250 citizens versus one lawyer for every 24,000 people in the rest of the world. Over 15 million lawsuits are filed annually. That works out to one new lawsuit every 2 seconds. With the control of all three branches of our federal and state governments by this single and specific group, there has been established a ruling class that has altered the former system of government from a republic to one of an oligarchy. The history of this usurpation of power by a lawyer class has presented us with the establishment of an absolute tyranny over the 50 states of the Union. To prove this, let the facts be submitted to our modern media-biased world, which was formerly discerned as a candid world by our founding fathers. Under the current system of attorney-lawyer control, the lawyer class in America has spawned an endless amount of laws and regulations that have resulted in the loss of liberties unimagined by our forefathers and in direct conflict with the spirit and the intent of the Declaration of Independence and the Constitution. Because of the attorney-lawyer domination and control of all three branches of government, any reform has been and is impossible. Under the current system of attorney-lawyer control, the lawyer class resists truthful facts or behavior as being either right or wrong, and instead accepts only winning or losing outcomes, exempting any notion of legal or illegal behavior. With little or no regard for law, attorneys' lawyers are only interested in exacting extravagant payment for service, win or lose. The declining values that follow this mindset are soon reflected in how we are governed and in the very nature and morality of American culture. Because of the attorney-lawyer domination and control of all three branches of government, any reform has been and is impossible. Under the current system of attorney-lawyer control, the proliferation of the number of attorneys, lawyers in America has created a need for an ever-growing revenue stream, producing a lawsuit industry that is among the most profitable industries in America. This ever-growing industry represents the least productive and indeed the most destructive enterprise in America, with frivolous and class action lawsuits. These lawsuits have made billionaires of unscrupulous attorneys, lawyers, while bankrupting American companies and at times driving otherwise noble American citizens to suicide after losing their business and destroying a lifetime of work and savings. Because of the attorney-lawyer domination and control of all three branches of government, any reform has been and is impossible. Under the current system of attorney-lawyer control, the proliferation of lawsuits that seek jury awards in place of justice and accountability has deteriorated the American character from one of self-responsibility and a can-do attitude to one of an unaccountable victimhood and a can-sue grab for money at the prompting of an ever revenue-hungry growing number of attorneys and lawyers. Any reform has been and is impossible with attorneys and lawyers dominating and controlling all three branches of government. Under the current system of attorney-lawyer control, the attorney-lawyer class has managed to facilitate the degradation and disparagement of the traditional family, which has been the bedrock of all civilized society since the beginning of recorded history. Their control of the legislative and judicial process has created an extremely lucrative divorce industry that incites the destruction of marriage and utilizes children as pawns in that process. Because of the attorney-lawyer domination and control of all three branches of government, any reform has been and is impossible. Under the current system of attorney-lawyer control, doctors and medical facilities have had to inflate their costs and provide unnecessary services in order to meet the ever-increasing and lingering threat of lawsuits seeking money rewards for any deviation from perfection that a trial lawyer can present before a lawyer judge and a manipulated jury in a courtroom. The decimation of America's world-envied medical system is only a matter of time as doctors and medical facilities quit and close down in the wake of these malpractice lawsuits. Because of the attorney-lawyer domination and control of all three branches of government, any reform has been and is impossible. Under the current system of attorney-lawyer control, the monopolistic and self-serving activities of the legal profession have created a state bar, which subsequently quashes any realistic justice for unethical conduct of this privileged class, and have rendered attempting just punishment a stage of collusion. They solicit expungement of any documentation of their wrongdoing by surreptitiously concealing that which would be considered contentious by most. Attorneys, lawyers, and judges have conveniently separated themselves from many of the laws that govern the other associations, businesses, and the citizenry. This is in direct conflict and defiance of the principle of equal protection under the law, as stated in the 14th Amendment to the Constitution. Because of the attorney-lawyer domination and control of all three branches of government, any reform has been and is impossible. Under the current system of attorney-lawyer control of all three branches of government and the lack of accountability that is derived from this influence, judges, both state and federal, are now creating laws by way of judicial activism and by a lawyer-created instrument called case law, which is directly in violation of Article I of the United States Constitution because of the lawyer-attorney domination and control of all three branches of government. Any reform has been and is impossible. Under the current system of attorney-lawyer control, lawyers practice and develop habits which do not serve the people. Lawyers often ignore cost and common sense. When a lawyer is paid by the hour, his habit of passing laws in Congress which are complex, ambiguous, and inefficient to administer profits his profession greatly, as does his habit of increasing conflict among differing parties. These are indeed not the characteristics a conscientious representative and lawmaker need to advance and ensure our republic and the freedoms of its people. Because of attorney-lawyer domination and control of all three branches of government, any reform has been and is impossible. Under the current system of attorney-lawyer control, dominance of the judicial system of America is controlled nearly 100% by attorneys, lawyers, and the bar associations to which they belong. As members of Congress, they have passed their own laws and regulations which ensure their monopoly on our judicial system. Corruption amongst the members of the bar is mostly adjudicated by the bar itself. The result is that less than 2% of the complaints ever receive any formal prosecution. Such disregard for the law by a specific group of people would normally be prosecuted under the Racketeer Influenced and Corrupt Organization Act, RICO Act. Any other profitable business or organization operating with such monopolistic power would have long ago been dismantled under existing antitrust laws. Because of the attorney-lawyer domination and control of all three branches of government, any reform has been and is impossible. Under the current system of attorney-lawyer control, numerous unconstitutional practices by the judicial branch promote the monopolization of nearly 100% occupation of judgeships by attorneys' lawyers. Nowhere in the Constitution is it mandated or even implied that a magistrate charged with the administration of justice has to be a lawyer. The wisdom and common sense of a vetted citizen would not only be more equitable, but it would restore quality and confidence in a system that has deteriorated to the point of no return under the current management. Because of the attorney-lawyer domination and control of all three branches of government, any reform has been and is impossible. The current system of attorney-lawyer control had its inception in the Supreme Court's 1803 decision of a case called Marbury v. Madison. The court usurped the power to the final arbitrator of defining the meaning of the Constitution. Thomas Jefferson strongly disagreed, noting that nowhere in the organic Constitution was the court given this absolute power. Jefferson was prophetic when he warned then that if this view of judicial power became accepted, it would be placing us under the despotism of an oligarchy. Later, in 1857, Abraham Lincoln said, "The idea that 9 people, 9 attorneys, lawyers on the Supreme Court, could make the law means that freedom for the rest of us would be eliminated." He repudiated the Supreme Court's decision in the Dred Scott case, saying that a Supreme Court decision is not the law of the land. It is the law of that case. The court does not have the power to create the law of the land. Indeed, 2 of the greatest men in our history foresaw the destruction that this Supreme Court could bring. Only those in the attorney-lawyer class would have the arrogance to dispute the wisdom of 2 such men. Another more recent example, on January 22, 1973, some 170 years after Jefferson warned of giving such power to the Supreme Court, and 116 years after Lincoln's repudiation by preempting and circumventing Congress, the court handed down a constitutional ruling on a non-existent piece of legislation. The court had legislated from the bench. This is what we were warned would happen. This is what ultimately has happened. The Supreme Court has demonstrated in numerous decisions that it is not averse to legislating from the bench in direct opposition to the powers bestowed on the court by the organic Constitution. The facts, as stated above, are but a very minute representation of the injustices and the inequities that have proliferated under the oligarchy of attorneys, lawyers now ruling America. The list of grievances over the last few decades grows beyond inclusion in any one document or even a book. The multitudes of factual references and support of these grievances are easily available to anyone via the Internet. Many noble and patriotic citizen groups and organizations have attempted to correct this lethal infection of the government for decades with little or no success. Thousands, if not millions of Americans, and yes, even patriotic attorneys, lawyers, have labored for years and spent their own savings in a vain attempt to restore our organic constitution and the republic form of government that it structures. The efforts of all these patriots have been in vain. Greed and the thirst for power by an attorney-lawyer culture have prevailed. This is to be expected when attorneys, lawyers make the laws, administer the laws, and enforce the laws. The attorneys, lawyers dominate our government and have been in charge for decades. The result is that a once great nation, envied by the world, is now on the brink of bankruptcy and a cultural mess that shares no resemblance to the great Judeo-Christian foundation upon which America was built and prospered. We are not in uncharted waters in calling for the prohibition of attorneys, lawyers from government. In deference to the genius of the Founding Fathers, a little-known historic fact is that the original 13th Amendment of the United States Constitution was enacted by Congress on May 10, 1810, and it established a prohibition of attorneys, lawyers serving in public office. It is also known as the Titles of Nobility Amendment. In simple terms, it prohibited persons with titles of nobility from being in public office. Attorneys, lawyers, then known as barristers, now known as esquires, having derived the tradition from England, were considered noblemen and part of an upper class in England. Their position of nobility made them suspect as to their qualification in making decisions in a new government, where the very premise was that all men are created equal. So the purpose of this 13th Amendment was explicitly to prohibit, among other nobles, attorneys, lawyers, from serving public office in America. In addition, the original 13th Amendment prohibited emolument, presents, and pensions to all those publicly elected officials with strict consequences for non-conforming actions. The original 13th Amendment was eradicated, hidden, so that American bar associations, which began to appear, could exercise political power. In their wisdom, the Founding Fathers foresaw the potential problem which today has produced the oligarchy which now controls our country by deceit and illusion. Article 1 of the Organic Constitution defines the separation of powers in our government. This separation of powers serves several goals. Separation prevents concentration of power, seen as the root of tyranny, and provides each branch with weapons to fight off encroachment by the other two branches. With the domination of attorneys, lawyers occupying the majority of public offices and support systems in all three branches of government, this constitutional safeguard has been breached by a specific and now all-powerful group of people. The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. James Madison, father of the Organic Constitution. With attorneys, lawyers dominating all branches of government, we now have the very definition of tyranny. In order to restore our country and further avoid an impending demise, we simply need to restore the 13th Amendment, banish attorneys, lawyers from any government-elected positions, dismantle the lawyer oligarchy, and replace it with true representatives of the people. Indeed, we, the people. In order to achieve this end, and in order to accomplish this through nonviolent means, we, the people of the United States of America, pledge to restore constitutional law, financial security, creative spirit, and the exceptional character of our nation by dismantling the existing ruling class of attorneys, lawyers. Our founding fathers pledged their lives, their fortunes, and their sacred honor. They fought a great revolution against all odds with the most powerful country of the day. They prevailed and created the greatest nation known to mankind, and since then, millions of young Americans have fought and died to preserve our freedoms and the future of this country. We are forever indebted to these great patriots. Our fight for independence today is simple and direct. There need be no sacrifice. There need be no loss of fortune or honor. There need be no bloodshed. Divine providence once again shines its favor on our land. Our founding fathers had the wisdom and the foresight to provide us with a weapon to fight tyranny in a way the original colonists could only dream of. This weapon is called the ballot box, placed in the hands of the people at a time before the usurpers of government can dismantle it. This is the weapon that can restore our independence without a shot fired. Therefore, we the people of the United States of America do here and now, on this 25th day of November, in the year of our Lord 2012, do solemnly pledge that we will not vote a candidate to any public office or judgeship who is an attorney lawyer. We will reconstruct the Supreme Court under the spirit and guidance of the Organic Constitution. We will restore the Organic Constitution as the governing document upon which America's government is based. As it's stated in Article 1, Section 1 of the Organic Constitution, all legislative powers herein granted shall be vested in a Congress of the United States. There is no provision for any other branch to make or create law. Be it state or federal, case law and judicial decree will only have standing in the individual cases upon which the decision rests. They will have no standing to parties outside of said case or in any other American courtroom. We will restore the doctrine of separation of powers and pass legislation to ensure its longevity against those tyrants who would take advantage of a lethargic electorate. We will restore the quality and respect of the judicial branch by returning control of our judicial system to the citizens who pay for it and for whom it must benefit. Chief among this will be the installment of citizen judges to replace the attorney-lawyer judges. We will restore the confidence and respect of our laws by demanding uniform ethical court procedures and legislating tort reform. We will abolish the current system and misuse of law, which has created a lawsuit factory and cash cow for attorneys, lawyers out of once was a system of justice we all respected. We will restore and reaffirm the 14th Amendment of Equal Protection under the law. No member of the government or elected representative will be exempted from any state or federal laws. Our constitutional laws and guarantees govern only legal citizens of the United States. Legal alien residents and foreigners are governed under federal statutes and state laws when within the border of the United States. We will restore the government to the republic governed by true representatives of the people and not by this privileged group. Term limits for public elected positions shall be established and set for all 535 members of Congress and the Supreme Court. The Founding Fathers, in the original Declaration of Independence and Organic Constitution, founded a republic, not a democracy. The essence of that republic is to ensure there shall never be a privileged group. By and through this declaration to reinstate the original 13th Amendment, we reassert the essence of the republic established by the founders and accept Benjamin Franklin's challenge. We are resolved to keep it. No group shall dominate all three branches of government. We will get our culture and our country back, and we will restore the character, the class, and the glory that is the United States of America. And for the support of this declaration, with a firm reliance on the protection of divine providence, we will qualify these declarations and construct them within the foundation of our government. We pray that once again, as President Lincoln so eloquently stated during the Great Civil War, this nation, under God, shall have a new birth of freedom. and that government of the people, by the people, for the people, shall not perish from the earth. And for posterity, we reclaim and re-ratify the original 13th Amendment to the organic Constitution for the United States of America. Article 13. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any king whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them, or either of them. Governance is a service and must never be anything more or greater than a service. Political parties, career politicians, top secret or veiled documents are not to be tolerated. The usurpation of grand juries is repugnant to the people and is hereby repealed. All office holders and legislation in contradiction to the organic Constitution are here and now repealed by we the people. Let it hereby be known and stated for posterity, the source of the language used in the Declaration of Independence above can be none other than the law dictionaries published and existing in 1776. Let no man attempt to redefine the meaning of words by any publication having come into being thereafter. The source of the language used in the American Sovereign Authority, the surrender of separation and power doctrine, was and will remain forever after the New International Webster's Concise Dictionary, copyrighted 1998 edition. In all instances in this document, we the people, when referring to our Constitution, refer to the organic Constitution of 1787, ratified in 1789, the Bill of Rights, ratified in 1791, and amended thereafter to include the original 13th Amendment. No other version of the Constitution or Bill of Rights is recognized or accepted by the people. We the people recognize no authority outside the lawful confines of these documents. In witness whereof, we have hereunto subscribed our names.